Right, we are live. Today is July 14, 2026, another Tuesday, and we are doing our second live with Attorney Leila here. And we had another week, with the developments in immigration law. But this week there was not major updates from USCIS. Mostly we saw news regarding ISIS operations, and there were unfortunately 2 killings. And maybe many of you heard about that. In just 5 days, ICE detained more than 10,000 immigrants, regardless of even if they have no criminal history. They got detained, and some of them also were entrants who entered the U.S. With valid visas, not just entered from the southern border. So we will talk about briefly regarding what has happened last week, and then we will start taking your questions. Leila, welcome again.
Thank you so much.
So I believe we started last week regarding some EB5 developments, and you mentioned that the rule will elapse in September 2026. I mean, it is safer to apply by that time to get the grandfather protections. But you will also, I guess, talk about something new today. Do you want to start with that?
Well, an update we have now is that for nationals of India, there are no visa numbers available in the EB2 or EB5 unreserved categories. They can still apply, and they should apply if they want to take advantage of the September 30th, 2026 deadline, but there are no visa numbers available until the new fiscal year for USCIS, which starts October 1st, 2026.
So you said Indian nationals?
Yes, Indian nationals.
Indian nationals, okay. So there is no visa numbers available this year until the next fiscal year, right?
Correct.
So when is that?
October 1st, 2026.
Okay, so if I am expecting adjustment of status application, and if I am an Indian person, I should not expect anything until October 1st, is that right?
If the underlying I-140 is an EB2 or an EB5 unreserved.
Unreserved category.
Correct.
All right. But if I am planning to apply now, it is still allowed?
Yes.
All right. Thank you for that. And do you want to briefly talk about the current PERM processing times for EB3 applicants?
In general, I believe July 9th, the Department of Labor published processing times to certify a PERM, and it's 403 days to have a PERM certified. So employers and employees should take that into consideration, because there's still the prevailing wage determination step and also the recruitment step. So all of that should be taken into consideration, and make sure that you're applying for the PERM well in advance of your H-1B max out date.
Okay. So like if I want to take a look at the whole process, even before we reach the USCIS stage, right?
Yeah.
There has to be the first step of requesting a prevailing wage determination.
Yes.
How long does it take to get that determination now?
It's between 4 to 6 months.
4 to 6 months.
Yes.
And then the employer has to do the recruitment process.
Correct.
To show that there is no willing and qualified employees,
Yes.
U.S. Employees. It takes around 2-3 months at least.
At least, yes.
At least. And then once we file the 9089 form, which is the PERM application, now it takes, you said, 403 days, which is close to 13 months.
Yes.
Yeah. And we just got one PERM certified this week and last week, and it was pending for about 12 months. So it is kind of correct. And so if I am planning to do EB3, I need to take that into consideration. And by that time, I need to maintain my status in the United States.
Yes,
okay.
correct.
All right, and I also heard some news regarding regarding a member of Congress. I don't recall exactly who that was. Proposing a rule change regarding the recruitment stage, and if the rule becomes a law, then they will require employers to do more recruitment efforts on the more popular sites, I guess, like LinkedIn and other more current employment recruitment practices. Am I right on that?
That's what I believe is going to happen. Let's see if it's going to pass.
Yeah, and also you have mentioned to me before that the Department of Labor had a case against Meta. What was that?
Essentially, what Facebook was doing, they were basically having two separate recruitment processes. So if the person was a foreign national, the way that they would advertise for that position would be different from when they were hiring Americans. Basically, they were hiring Americans through LinkedIn, through their website, posting on intranet. So the Facebook decision essentially said that you have to have the same recruitment process, regardless of whether it's a foreign national or a U.S. citizen or an LPR. So I believe that's what they're trying to put into law now, so that everyone follows the same process for recruitment.
Definitely. So technically, the administration will say that you cannot have two different strategies for PERM cases and like your regular hiring process. Correct. So it has to be standardized.
Correct.
All right. So I guess they are trying to make it kind of harder for every category now. Yes. Like we see asylum applications are getting more scrutinized, WAVA applications are getting scrutinized, and now even with EB5, right? Yes. So they proposed gold card, and we don't know if the EB5 will be renewed. Yes. And now EB3 is another. I think they will make it more challenging to get EB3 PERM certified and approved, I guess. All right. Before we start on answering the questions, do you have anything else to mention from this week?
I just believe that the only thing is that we touched upon it last week, the signature rule with USCIS. That is something that I see a lot of emphasis on, and something that I want to remind everybody to make sure that they're signing the paperwork with a pen, and then scanning and sending it back. And I believe they also have some policies saying that you should keep the page that you signed, just in case USCIS ever decides to ask for it.
Yeah.
So just keep that copy.
Definitely. And I also like doing online applications. I believe it is safer because, you just get the receipt notice very soon.
Right away.
And the online applications fees are lower, but not every application can be done online. Yes. So still there are some applications that need to be done on paper, and if you do it on paper, don't use electronic signatures.
Yes.
And do the hard work and scan it and keep the copy of the original in case they will ask for it.
Correct. Yes.
All right. Okay, we can get started. We have a few questions. I hope that we can answer them very quickly. All right, so this person asks, hi, if an I-130 and I-485 is denied after a Mandamus proceeding, is there still a possibility that an NTA will be issued even if an I-589 is also pending? If yes, what are the odds? Thanks. So during this administration, they are now enforcing denials a lot more. And in the previous administration, even if you receive a immigration benefit application denial, sometimes nothing would happen.
Yes.
But it is currently there is more likelihood that you can receive a notice to appear if you do not have a valid status, and your deportation proceedings, your removal proceedings can get started, and you need to maybe hire a lawyer for that process. So what are the odds? So during this administration, we received some denials. For example, I remember receiving a denial for an adjustment of status applicant who got selected in the DV lottery, but that person did not have a valid status in the US.
Okay.
She was just an affirmative asylum applicant. In the past, we had these cases approved, but now they have a policy and they say that affirmative asylum does not constitute a legal status in the US, so you cannot adjust status in the US just because you have an affirmative asylum application pending. So we got that denial, but I was concerned about my client, whether she would put in removal proceedings by getting an NTA, and nothing has happened. But many immigration attorneys are also reporting that after getting denials, their clients are also getting referred to the immigration court for removal proceedings. So we cannot say that it will happen for sure, but the odds are much higher right now. Do you have anything else to say?
So this individual said that they already have an I-589 pending. I don't know if that's going to prevent them from issuing an NTA. But if they are concerned, a tip might be to file an appeal, an I-290B, just to keep it in process and have an appeal going on with USCIS, maybe while the 589 is being adjudicated.
Definitely, it will save them some time.
Yes.
And if the I-589 is also pending for a long time, you can try to do a Mandamus case for that if your asylum application is strong.
Correct.
But I also know that even if you don't have any application denied, current administration sometimes takes some pending affirmative asylum applications and they just NTA them. So they don't have to technically hear your case before asylum office, and asylum office can refer you to immigration court even before holding an asylum interview. This has never happened to me before, but this is happening now. Luckily, none of my clients had this issue. Only a couple of my clients who had their affirmative asylum applications pending got detained. Like there was no reason, there was no criminal history, but they got detained. And once we filed the bond motion, they also received the NTA, and their asylum application process now is pending with the immigration court. So this can happen. And so what Leila said is very important. Generally, filing a 290B can be very helpful in this situation.
Yeah, it might prevent an NTA just because USCIS will see that there's an appeal pending. But also, I'm not sure why this case was denied. What do you think about if it is a real case and a strong case, refiling?
Yes, so there are two options. So if after the denial 30 days has passed, right, the 290B deadline, you have no choice but to refile.
Yes.
But if I guess, in my personal opinion, I generally recommend filing a 290B because it will likely prevent them from issuing an NTA. But refiling does not. So it will not automatically link your new case to the previous case.
Correct.
So it is more likely that you will receive an NTA.
Yes.
Generally, they scrutinize I-130s and I-485s much more. If it's a marriage-based case, now they can do Stokes interviews, like interviewing the spouses separately, asking very detailed questions and try to try to see if the relationship is genuine. And they can also, the FDNS unit, if I'm not mistaken, FDNS unit, the fraud unit, can pay a site visit to see and ask about relationship to your neighbor and your employer and your father-in-law, for example, right?
Yeah.
So these are happening quite commonly right now. All right, I think we were detailed enough for this question. And another client, I have an OPT EAD and I applied for asylum with your help this week. Can I use my current EAD for Uber and DoorDash, or must I wait for the asylum EAD? I understand OPT EAD may not allow this. I am your client and would appreciate a clear answer. So I want to take this one. So first of all, even if you engage in unauthorized work, it does not prevent you from getting an asylum in the US. Many of my clients clearly declared that they had to work without authorization while their initial asylum applications is pending, because they had, they had to get some income to feed their family members and stuff. And asylum officers are understanding, because generally there is 150 days of waiting period before applying for initial EAD. So even if you work without authorization, it might not be a problem for the asylum application, but keep in mind that you are working without authorization. So we cannot advise you to work without authorization as licensed attorneys. But what I say is, it is not automatically preventing you from getting an asylum. So it is another bar. And for OPT EAD, you can answer that better. I guess it has to be relevant to your education.
Exactly. In OPT EAD, the work that you're authorized to perform under OPT EAD is something that's relevant to the degree that you've obtained. So essentially, it's offered so that you can get some experience in the field that you've studied. So if it's not related to the field, like DoorDash, then essentially you can't use your OPT EAD for that.
Yes. All right, I think we were detailed enough. And another question. In the last week's live, you mentioned someone who entered on a visa, applied for asylum, and was suddenly detained by ICE. Was it because they applied after their visa expired? Why that person specifically, when so many do the same? Any idea? A great question, actually. So I was asking AI this morning whether ICE is using like cities and counties cameras, traffic cameras, to associate them with the owner of the car. And yes, I see that the answer was yes, even though sometimes local agencies, local administrations do not share those information. But currently, many more local government or agencies share information with ICE because of the federal government's pressure. And why that person, we don't know. So he was using that road every day, but all of a sudden they detect the license plate, and then four ICE vehicles surrounded the person, and then 12 people got him and detained him. There was no apparent reason. There is no criminal history, and this can be a common practice. And I also had another client whose asylum application eventually got approved. He got his asylum interview in Newark, and then while the decision was pending, the ICE officers stopped a vehicle registered on his name, but his friend was using that car, and showed his picture to the driver, saying that, do you know this guy? So I guess they can associate license plates with the IDs, so they can stop the car. So it is very concerning, in my opinion. And my client never left their house for 3 months, and after 3 months, the asylum approval decision came. Like, if you will approve the asylum application, why do you try to detain these people?
Yeah.
These people came with visas, and the affirmative asylum applications are pending. So it doesn't make sense to me much, but they do it. And for this person, I was talking to Leila about this case. We filed our bond motion, and we will have our bond hearing on Thursday. So hopefully we will have him released on a bond.
I feel like this is separate departments acting separately, because I know a little while ago, if you remember, in California, ICE was going to USCIS office where they were going to adjudicate the 485s, I-130s based on marriage, and they were detaining spouse of U.S. citizen while they were attending their interviews.
Yes, I heard about that too. So I guess it was in San Diego.
Yes,
Am
San
I right?
Diego,
Yeah.
yes.
And they even detained like the spouses of army members
Yes.
and stuff. So it was so concerning, but they stopped doing that practice, right?
Yes.
So I guess so they receive orders in certain periods and to just collect
Yes.
more numbers.
Yes, a certain amount that they have to,
Yes.
a quota that they have to meet.
And even they know for sure that these people will be released on bond
Yeah.
later, they don't care. And sometimes, like another attorney was sharing their experience with an asylum office. So they attended the asylum interview, and the officer, left the room at some point and came back and told the attorney, saying that, I am sorry, this was not my idea. And after that, they saw the ICE officers and they took the client into custody. And once the attorney tried to challenge them, asking questions, the attorney realized that they don't know much about the case. They don't know much about the law. They just, complete by the orders,
Yeah.
This is so sad. All right, so another asylum question. If my asylum is denied and I later marry a US citizen, could my criminal case in my home country and the risk I'd face if I return qualify as an exception to avoid consular processing? So first of all, to adjust your status to a green card holder in the US, what matters most is how you entered the US. So if you entered without inspection, and if you were not paroled, or if you did not use a visa, you cannot complete the process in the US at all.
Yes.
Am I right on that?
Correct. You need to be inspected and admitted.
Admitted.
Yes.
But if you cannot go back to your home country, then what you can do is requesting a consular processing at another post, at another consulate in another country. And maybe you can talk about that, but if I'm not mistaken, the DOS brought a new rule that you cannot get interviewed in other countries unless there are some humanitarian exceptions. Are you aware of that rule?
I don't know about the humanitarian exception, but my understanding is that as long as you have legal status in that country, so if you're there on a work visa or I guess some kind of humanitarian visa that allows you to stay there, then you can go through consular processing.
Yes, so I guess they require you to, if you are a citizen or if you are if you have a residency in that
Yes.
country, you can go through the consular processing in that country.
Yeah.
However, I think I remember this clearly. Even if you don't have residence, you can talk to the consulate in another country saying that I cannot do consular processing in my home country because of my fear. So it can constitute a humanitarian reason. So if the other post accepts your case, then you can go through consular processing in that country as well. It is my understanding. Let's say if you talk to, if a country do not require you a visa as a certain national, you can technically go to that country to complete the consular processing. But the problem there is you still have to use your home country's passport.
Yes.
And if it is expired, you cannot renew it, probably because of the persecution you're afraid of. And I have never done this process before. I have cases pending, I-130 cases pending, and we are planning to do consular processing in other countries. It can be challenging for sure.
I guess what I would want to know is that if this person is denied his asylum, will he take voluntary departure, and where would he go to? Or would they remove him, and how would they remove him to a country that he doesn't have like a passport or citizenship from?
Yeah, so I don't know for sure if this person is has an asylum application pending before USCIS or immigration court.
Okay.
So technically, most of the time, immigration office cannot deny an application. They just refer to the immigration court.
Yeah.
And if you are denied by the immigration court, then you are technically, you receive a deportation order,
Yes.
removal order. I guess it can be very challenging after that process if you have it might require a individual consultation, but if you have a BIA case pending, for example, can you do that?
Mm-hmm.
Because you have you technically have a removal order.
Yeah. So either way, marrying a U.S. citizen will not help him because he still needs to do consular processing if he entered without inspection.
Yes. Yes. All right. So. All right, another question. I'm not sure if we answered this question last week, but let's see. We married within the 90 days. However, we took an extra month and a half to send the I-485 form due to personal reasons. If the officer asks if I was under overstay, should I say yes? Came with K1 visa. So for no, this question was not asked last week. It was a different question who entered via tourist visa, and I am kind of relieved to see in the end that is K1 visa. So if I come to the US with a fiancé visa, I should get married in the first 90 days and then apply for adjustment of status. Yeah. But I wouldn't worry a lot in your situation because you are married and you just apply later. But do you have anything else?
Yes, I agree. I agree. As long as they were married within the 90 days, even though it took him some time to apply for the 485, that should not cause any issues. But if the officer asks if he has overstay, I would say yes to that because that is a yes, but he's married to a U.S. citizen. So
yes. And entered with a visa,
yes.
There is no bar applying to them.
Correct.
Getting the green card in the US. There is a Turkish question. Let me translate this.
Looks like a final merits issue.
How did you understand that? Oh, so they asked. Oh, okay. So there is also English version.
Oh, there is?
Thankfully, yeah.
Okay.
So they ask USCIS approved for EB-1A criteria, but denied their case at the final merit determination stage. Should I refile EB-1A or file an APA lawsuit based on Nebraska decision or pursue NIW? So I can definitely talk about the lawsuit portion, but I just want to hear you first, and then I will talk about that.
I mean, so this is what we were actually talking a little about last week, where we were saying that because of the Trump green card, they need visa numbers. And so they have to find the visa numbers from somewhere in the EB categories, and they were pulling it from EB1s and even EB2s and IWs. And that is why we're seeing these denials, even though the person meets 4 criteria. Then on the second part, the merits part, where it's discretionary, that's where they deny these cases so they can pull the visa numbers from. Now, the case essentially said that the final merits was not implemented the way it was supposed to be implemented. It didn't go through the 60-day comment period. So this case is fairly new, and I do believe that I've heard people saying when you file a lawsuit, these cases are getting approved. I don't know, that's not my experience. I've heard about it. I'll let you.
Okay.
Yeah.
So I have a few cases pending regarding this issue, and even in one of them, USCIS has considered that 6 criteria were met, and then they denied the EB1A application based on the final merit determination. And we filed the lawsuit, and shortly after that, they reopened the case, and now they issued a NOID, and I believe they decreased the criteria amount from 6 to 4. And now my client is answering the NOID and notice of intent to deny, and we will see whether it will be approved. So since it is NOID, I am kind of pessimistic about that. And I also have another client. We will file their lawsuit very soon, and his last name is also Mukherjee. So same last name with the famous case. So we'll see if you'll be able to get these cases approved. But I guess USCIS's strategy is, instead of fighting the lawsuit, they just reopen the case and issue a NOID. So it is concerning, but we will have more information by time. Do you want to also address the NIW part?
I mean, if somebody, in my view, I don't know this person's resume, but if they met 4 out of the EB1A criteria, they might be a good candidate for the NIW. So if you're not from India, NIW will work, because in most categories, in most chargeabilities, NIW is current. But if you're from India, that's not going to help. There's still going to be a backlog.
Yes, and for NIW, we can also do technically concurrent filing with I-485 for most countries, right?
Yes.
But the issue, I guess, is the EB1 criteria and EB2 criteria, even though they are similar. For EB2, there should be a proposed endeavor.
Correct.
And
national interest. Yes,
yeah.
National interest. Yes.
Okay. Let's go to another question. Hello, could you please share some U.S. citizen marriage-based interviews experience from last couple of weeks? If you had any, we are curious about the officers, mostly asking about marriage or other stuff, I guess. So our attorneys attended a few marriage-based green card interviews in the past few weeks. We were concerned about that they were going to be asked questions regarding memo. Most of them, they were not questioned about that. But we can say that they were detailed, and the interviews most of the time took around 2 hours. In the past, it was not the case, much shorter, and they were detailed. They were very detailed about the bona fides of the marriage, and there were some questions. So I guess there has to be a very detailed preparation needed.
Yes, I actually was really surprised, because I had not attended an interview in Newark for a very long time. And then when I went to Newark, while I was sitting there, I had a marriage-based case. But while I was sitting there, I saw that most of them were Stokes interviews. So most of them, I saw that they were first calling in one spouse and then calling in the other. Luckily, that was not the case, but I was really surprised as to the amount of Stokes interviews that were being conducted at Newark.
Definitely. So I attended the American Immigration Lawyers Association's annual conference, and other attorneys were talking that, for example, in Boston, it is now the standard procedure.
Oh, wow.
They separate every single case, they separate spouses and then ask questions separately, and it is concerning.
Wow.
All right. Last two questions. I have been approved I-130, paid our fee. What do I need to continue? Are there any more fee to pay? Do you think I have a good chance to be approved? So if you have filed I-130 only, and if this is a petition for someone who's overseas, now the second stage of NVC, National Visa Center proceeding will start, and you will have to pay immigrant visa fee, and there is also I-864 affidavit of support fee. I believe it. One of them is 325 and the other one is 120. So the total fees should be $445 if I'm not mistaken. So yes, there is separate process and there are separate fees. And if the beneficiary is in the US and if they will apply for adjustment of status, they need to file the form called I-485, adjustment of status application, which carries a $1,440 of fee. And if you will apply for work authorization and advance parole, those are separately $260 and $630.
Yes.
Do you think that I answered this question?
For the consular processing, also once the visa is issued before entering the US, it's the immigrant visa issuance fee, which I believe is $220 as well.
Yeah, so just to get the physical green card, you need to pay that $220.
In advance of entering the US.
In advance of entering, yeah. And sometimes they are delaying those, in the mail, I guess, because sometimes people reach out to me saying that, oh, I paid that fee 3 months ago and I still did not. Did you have any cases like that?
I actually had only one case like that. It didn't take 3 months. It took about 2 months, but eventually they sent the green card. Yes.
Nice. Okay, so hi, for EB2 NIW initial filing, would I be able to concurrently file for EAD while the file is pending, since I am from rest of the world, not India or China, or I would need then approval before EAD? So if you do I-140 and I-485 at the same time, you can also concurrently file the I-765 and I-131. So they are not tied to I-140 approval.
Correct.
So you don't have to worry about that. All right. Thank you everyone for attending. It was shorter than last week, but we still had 13 people. It's something. And by time, we are planning to do these lives every Tuesday at 2 p.m. And hopefully it is helpful to everyone attending. Do you want to say anything else?
No, it was really nice being here for the second time, and hopefully we continue to build on our viewers and answer more questions and help people.
Thank you, Leila. Yes. I really appreciate it. All right. We will see you at the same time next week here. So please do not forget to turn on your reminder for the next live, and we'll be here. Have a great week, everyone.